Okay, we're going to finish off corporations as a risk management tool in this video, picking up from the previous video where we left off talking about the ways that the corporate veil can be pierced in a corporation to make the directors and officers liable. I think it's important to look at the image in the textbook because, and I'll post it online in case you don't buy the textbook, which I think is silly, but some of you don't. You have liability, but it's one of three types really. There is criminal liability, there is quasi-criminal liability, and there is civil liability. And sometimes there's something sort of like double jeopardy. So looking at slide 85, for example, a pre-incorporation contract is merely a civil liability. You're responsible to compensate the injured party. Family law, civil liability, fraud, taxation, insider trading, all quasi-criminal liability in the sense that you can wind up with a criminal charge, but not under the criminal code per se. Criminal negligence under the criminal code, so you have a criminal record. You can't travel to the United States, for example, if you wanted to with the pandemic going on, but you have criminal liability. Human rights, again, is just quasi-criminal liability. You have to pay a fine. Environmental legislation, quasi-criminal. Employment standards is not a penalty, so it's civil liability. Workers' compensation, quasi-criminal. Competition Act, quasi-criminal. BC Business Corporations Act, Section 154 is just a fine under the Company Act, and so it would be considered to be penal in nature, so it's quasi-criminal, but you have to compensate the injured party, so it's civil as well. Consumer Products Safety Act is quasi-criminal. Guarantees and covenants are just civil liability, okay? Now, fraud, for example, actually, I should back up, can be both. You have fraud provision in the criminal code, so you can wind up with a criminal record, but then you also have the requirement of paying the other side back, and so you have civil liability. So there's this mixture. Okay, so now we're picking up at slide 87, and this is the thing about corporate governance that I've talked about very briefly. It shouldn't be corporate governance, it should be business governance. Enough said. Now we're going to look at the duties of directors, because last video we talked about the role of directors. So in the exam, if I said, what are 5 duties of directors, and you went, oh, section 136, aha, got it. No, you don't, because section 136 isn't a duty. It just outlines what the directors are responsible for doing as they carry out their duties, okay? So the first thing you have to wonder is, do the directors owe a duty to the shareholders? And in a purely academic way, absolutely not, okay? The directors are appointed by the shareholders to run the corporation. So they have a direct duty to the corporation, a number of duties. But they have no direct duty to the shareholders. And whenever I put this on the exam, students always struggle to find out, oh, well, they have a duty to make sure the financial statements are done, or they have a duty to, do things in the best interests of the shareholders. No, they don't, okay? They do not have a duty to the shareholders. Now, that being said, you can't exactly ignore them either, because, back up, shareholders elect the directors. Years ago, there was a situation where there was a coal mining operation in eastern United States, and it was a public company, and there was lots of shareholders. And for years, the shareholders had received no dividends at all. the board of directors, made up of 12 business people, were making over $1 million. I can't remember if it was like $1 million or $2 million. Let's say $2 million a year, and with salaries and benefits and bonuses and things. But the corporation was running at a small loss because of depreciation of the assets involved in a coal operation. And the shareholders got really quite upset about not receiving dividends year after year after year after year. And so finally, some of the shareholders that had over 5% of the shareholdings called an extraordinary general meeting of the members. Every year you have to have an annual general meeting of the shareholders. But you can have as many extraordinary meetings of the shareholders as you want. Anyway, they called this meeting, and in the meeting, the board of directors were on the stage, and they were asking them questions and everything. And finally, this one fellow stands up, and he says, okay, there's 12 people up there, and they're making $24 million a year, and year after year after year after year, and we're getting absolutely nothing. Is there anyone here that might be willing to work for $500,000 a year? And a whole bunch of hands went up, and they said, why don't we elect 6 people to run the company that make $500,000 a year, and that's $3 million. Take 3 away from 24, and that leaves $21 million to be paid out in dividends. And the board of directors on the stage went, bingo. Okay, so you cannot ignore the directors. Same thing, there was a bit of a problem with Starbucks, because Starbucks, when the directors were like, whoa, we can't believe how popular it is for people to just go and sit and drink coffee and pay, $5 for a cup of coffee. This is phenomenal. So they realized they were onto a good thing, and they wanted to open a store a day, basically. The motto was a store on every corner, okay? The idea being they get into the market fast and they take all the good locations before their competitors get on the stage. And so what they wanted to do is take all the profits they were making and re-put them into new outlets. The difficulty with that was, of course, the shareholders wanted dividends. And so the directors of Starbucks realized that they had to provide some dividends to the shareholders, otherwise the shareholders would not re-elect them to their very good positions. So again, you cannot ignore the shareholders, but you do not have a direct duty to them. The first and most important duty of the directors is in Section 142 of the BC Business Corporations Act, and it says that directors must act honestly and in good faith, like duh. But then it goes on to say they must exercise the care, skill, and diligence of a reasonably prudent person in the same circumstances. And there's that diligence word, okay? So in other words, you must run the company. It doesn't say you must run the company perfectly, but it says you must use the care and skill and diligence of a reasonably prudent person. So that's the main one, and that's what they call the due diligence defense. It's on the slide, but I'm going to write it on the whiteboard as well because it's so incredibly important. The due diligence defense. If you have the due diligence defense, then you do not have liability from the corporate veil being pierced. Okay. The next one you have to be a little cautious about for examination purposes, because I have on the screen put 2 sections down. They are not 2 duties. This is 1 duty outlined in Section 147, and then if the directors fail in that duty, then Section 148 kicks in. So the duty is outlined in Section 147, and it says directors must disclose interest in contracts. So we have a corporation, and there's a number of us that are directors, and my job is to seek out business opportunities. And I see this other corporation over here that has the patent on a wonderful invention, and I think, well, we should acquire that patent and we should develop it. The problem with the scenario is this corporation over here that owns the patent, there are 2 shareholders, and gosh golly gee, I'm one of those shareholders. Okay, Nothing wrong with that because I'm a director, an officer, and shareholder of this business, but they're not in competition, okay? So I can have shares in both and be directors in both. So I go to the board of directors of the company that I'm working for and I say, hey, we should acquire that patent. And it's going to, we'll buy it for $500,000 and we'll develop it and we'll start selling it. And we'll be making $2 or $3 million in revenue per year. So it's a really good idea. The board of directors vote. They buy that patent. What I have failed to do is disclose that I have an interest in that purchase and sale contract. As a consequence, when it comes to light that the $500,000 that gets paid to that business gets divided in two, and I receive $250,000, Section 148 kicks in, and I have to pay that $250,000 back to the corporation I'm working for because I have a fiduciary duty to acquire that invention as part of my job for the company. Okay, so Section 147, disclose interests in contracts. Related to that is a slightly different scenario. Here's this opportunity over here, and I'm in this company and my job is to seek out opportunities, and I have no interest in it. Okay, it's completely owned by somebody else, all right? So let's say it's owned by Myron and Wissa. And Myron approaches me, or I see the opportunity and I approach him and I'm trying to acquire it. And I think to myself, okay, if we acquire this invention, we're going to make $5 million a year on it once we're up and running. And there's 5 of us involved in this corporation, so that means we'll be getting about $1 million each a year. That's fantastic. Or, if I think about it, I acquire the invention, develop it myself, and then I make $5 million a year instead of just 1. Well, this is interception of a corporate opportunity, okay? And the law here is really strange, so listen carefully. In a Supreme Court of Canada decision, the judges said that is an opportunity that belongs to this corporation, and there is no way that I can acquire it for myself without the potential that I will have to take any profits I make and pay it back to the corporation that I'm involved in. Oh, okay, well, I'll resign and then I'll do it. No, because I was aware of it as a business opportunity before I resigned, it belongs to the corporation that I was working for. I cannot take it myself. Oh, well, let's try this. I go to the board of directors and I say, here's a really good opportunity. And they say, no, we're not interested. Oh, can I do it myself? Sure, okay. And then I go and do it. And I make a whole bunch of money. I'm okay, right? No, I'm not. I'm going to have to pay that money back. Once it's a corporate opportunity, it is always a corporate opportunity. I went to a continuing legal education seminar on one of the topics was this. And there were 60 lawyers in the audience, and there was 3 of them on the stage, and one of them gets up and talks about corporate opportunities. And he says, you cannot take it. 60 hands go up. Okay, how do you do it? And he says, I'm not sure you heard me. You cannot do it. Well, what if we did this? No, you can't. What if we did that? No, you can't. Well, what if we did this? No, you can't. What if I got a director's resolution by them saying that they didn't want it, never wanted it, wouldn't do it, didn't know it? He said, no, you're not safe. The Supreme Court of Canada decision says it is always a corporate opportunity. Okay, so you develop patents. Well, and this is a new shoehorn, for putting on shoes. No patent on it. Not your products. You're high tech. Is that a corporate opportunity? Maybe not, because it's not the kind of business that you did. So if you said, wow, I could make a lot of money on that, shoehorn, you could probably resign, go and do it and safely. If you got a resolution from them saying, we're not interested in it, even though it's the type of thing we do, you can go and do it yourself. You will probably be safe, but you cannot be absolutely safe. Simple as that. So you have a duty not to intercept corporate opportunities. You must disclose conflicts of interest. This is in Section 153 of the of the BC Business Corporation Act. What that means is I own property in this corporation and I own property personally or in this corporation. If those corporations compete, I'm in a conflict of interest situation. If I'm on the board of directors of this bank and I'm on the board of directors of that bank, how do I give that bank the best advice possible without giving it to them? And how do I, give it to them when it would have been profitable for them? But, well, it's obviously a conflict of interest and you can't do that. I can own shares in two banks, as I said earlier, as long as I'm not a director or officer or employee for those banks, okay? So you have to disclose interests. Now, Section 154 is one of those items listed in the circumventing the corporate veil list, okay? And the reason is that corporate opportunity, I'm part of the corporation, so if I have to pay the money back, they're not piercing the corporate veil or anything like that. But in this situation, we could be. So let's say there's three of us and we have a corporation and things are going really badly. Okay, we know we are going to be insolvent or perhaps forced into bankruptcy within a matter of weeks, if maybe a month. Well, just because we're insolvent does not necessarily mean we don't have any money, okay? Insolvency means in our bank account there is $90,000, but we owe $630,000, so we are insolvent, okay? Now, we owe all that money, and there's $90,000 in the bank, and there's three of us involved in the corporation. So we could take that $90,000 and we could apply it to the $630,000 that we owe, but it's going to hardly make a dent, is it? Okay, so we think, well, perhaps we should just declare dividends now. Dividends of $90,000, which means we each get $30,000. Now there's nothing there. We're still insolvent. No harm, no foul. Well, there is a harm, okay? And the harm is that we are jointly and severally liable to pay that money back. What's that mean? Well, let's up the ante. Let's make it really worthwhile. Let's say there's $900,000 in the bank. So we each grab $300,000 in dividends, and my two business associates go to Búzios, Brazil. Okay, we don't have extradition with Brazil. I can't. I have family here, kids are in school, and everything. So I remain here. This all comes to light. I have to pay my $300,000 back, don't I? No, I have to pay $900,000 back because I am jointly and severally liable to compensate the parties, okay? All right, so let's not pay ourselves let's go back to the $90,000 example. Let's not pay ourselves $30,000 in dividends each. Let's sell our shares back to the company and take a return on capital. Same thing, you're caught by Section 154. If you do that, you will be responsible for paying the money back to the corporation so it's available to the creditors. They can pierce the corporate veil and go after you. All right, well, let's try something different then. Let's say I'm the sole shareholder, director, and officer, so it's my company and I'm running it. There's $90,000 in the bank and bingo, I own all this money. Well, my wife has always wanted a house, and we're living in an apartment right now. So why don't I lend her the $90,000? She can use that as a down payment on a house. Now, she has to pay the money back, okay? So there's a payment schedule and everything like that, but she doesn't, okay? And then the creditors come and they say, hey, we want that money. Well, in a corporation, who makes the decision that the corporation should sue someone? The directors. Oh, that's me. Oh, okay. I'm not going to sue my wife. She'd kill me. Okay. So I don't sue the wife. The wife doesn't have to pay the money back. Well, they can pierce the corporate veil and they can go after me. All right, and the money. So that's Section 154. Section 192 is to refrain from insider trading. And I'm not sure, did we talk about insider trading at one point? I can't remember. Anyway, I don't think so. Maybe I'm thinking about my lectures for a different class. Anyway, yeah, we did. One insider trading is information that you have that no one else does. We did. It's all coming back to me. Okay, so let's say I have some information about our company and I'm a manager. I'm a director, an officer, or a manager, or a supervisor, or whatever, and I own shares in the company. And I know that we're going to expand and our shares are going to become more valuable. Well, it would be better if I had not only had my shares become more valuable, but if I had more shares. So I go out and I purchase shares before the public knows about it. And then the public finds out about it and they all begin purchasing shares and the value of my shares go up. This is insider trading. Okay. And the converse of that, of course, is that I know that the company has just negligently done something. It's going to be sued by a whole bunch of customers and we're going to be insolvent or bankrupt or whatever. And my shares are going to be worth nothing. That's if I sell them later. But if I sell them now before anybody finds out about it, hey, I get my money out and then you're on the hook for nothing. Well, that's insider trading. Who's caught? Anybody inside the organization that is managerial in nature and has this insider information, or anybody that an insider tells. Okay, so I don't own the shares in my company. My wife does, right? Because I've made myself judgment proof. And then I find out about this problem, so I quickly get on the phone, or I should go like this on my cell phone, and I say, hey, sweetie, you know all the shares in Gotta Have a Java? Sell them. Yeah, like right now. Like, I'll talk to you about it later. Don't worry about it. No. Sell. So that, she doesn't suffer a loss. Well, she's, in Ontario, she's called a tippee. I'm the tipper. I gave her a tip. I don't know whether we use that terminology in BC, but it's right in the Ontario statute, which is very similar to ours. Well, this used to be confined to public trading companies, and you would be charged with an offense under the Securities Exchange, or under the Securities Act, by the Securities Exchange Commission. They've put it into the BC Business Corporations Act now, and it applies to even private corporations. So let's say there's 5 of us, and we have some product, and I can see that, a competitor is going to come on the market, and the competitor happens to be this huge multinational corporation, and I know they're going to squash us like a bug. And so I go to my other shareholders and I go, okay, guys, I think I want to sell my shares. And they say, oh, okay. Well, I know some information that they don't, okay, and so I'm caught by this section. Who's caught by this section? It's very wide and sweeping. I think that the office boy who's running around, shuffling papers and delivering files and everything, overhears the director talking to another director about an opportunity. I am not sure that if they get this information indirectly and they're not given a tip, then they may be okay if they went out and bought shares. But anybody else is, including lawyers for the company. Okay, years ago there was one of my clients that was going to go public. Okay, and he got taken to the cleaners by the promoters, by the way. But anyway, he wanted to go public, and I had to do quite a bit of work on his corporate file before the corporation then became listed on the stock exchange. And he came to me and he said, okay, I tell you what, Peter, rather than my paying your legal fees, why don't you take shares? And then when we go public, you can sell your shares and get your money out, and you'll make way more money than you would just getting legal fees. And I said, no, I don't want to do that. But then it wasn't illegal It was unethical, okay, and it's hard to believe because a few lawyers give all the other lawyers a bad reputation, but most lawyers are incredibly squeaky clean, honest individuals because very few people go through 3 years of law school because they want to cheat. Okay, so anyway, I said no, and they went public, and the promoters took them to the cleaners, and the shares weren't worth anything, and so I would have lost money had I done that. Anyway, that's insider trading, and you have both criminal and quasi-criminal liability there. Okay, all right. The next portion is about 3 slides of things that you should consider putting into a shareholders agreement. And I don't think we're going to get into that in a big way. What I do at this point want to do is I want to stress that if you have a partnership, you should have a partnership agreement as a risk management tool to prevent as many problems as possible. It will not prevent all problems because nobody has a crystal ball to look into the future. If you have a corporation, then you should have a shareholders agreement. And I'm going to tell you an anecdote which I hope will drive this point home. And I have no ulterior motives anymore. I used to tell all my students this, and then some of them would go out and they'd get involved in business and they'd come back and get in touch with me. So I guess indirectly I could have been trying to generate clients. I have no interest other than as your professor making sure that you reduce your risk to the greatest extent possible when you go into business. I talked about my really good friend who went into that business and they did the shareholders agreement, and my wife put the little pictures of actual seals on the document as a joke. Well, let's go back and really do that scenario. There were 4 people involved in this corporation, and what they were going to do is they were going to do a cruise ship franchise, sell cruise ships, tour trips, right? And back then, there's a lot of businesses in it now, so it's not nearly as profitable. Back then it was brand new and there was a really good opportunity to make a lot of money. So he sold his advertising agency and he had this money. Another person he knew had some money, and so the 2 of them were going to invest their money and buy this franchise. Then they had 2 other people that were going to invest money but not be involved in it. So they had common shares and these other people had preferred shares. Anyway, initially the accountant says, do not do it as a corporation, do it as a partnership, because the write-offs are better, and if it turns out it isn't profitable, then you can carry the losses forward and back and things like that. So my client said to me, is that a good idea? And I said, well, there's not a lot of risk in this franchise operation. You get some, event cancellation insurance. So if somebody goes on a trip or is going to go on a trip and there's a problem with the ship and they can't go and they get mad at you for selling them a cruise, then you have your insurance to protect you. And so they said, okay. And they said, well, what else should we do? And I said, well, if you have a partnership, you should have a partnership agreement, particularly because they wanted to make an arrangement which wasn't provided for by the Partnership Act, okay? And what it was they're going to have this operation, and they're going to have a lot of agents working for them, selling these cruises, right? And so they were going to operate 7 days a week from 9 to 5. And one of them would be in the office 5 days, and the other one would be in the office 5 days, but they would overlap, so there was always somebody there managing it. And then they said, okay, we close at 5 o'clock. If either of us do any activity related to cruise ship franchising after 5 o'clock, then we get to keep the money personally, Okay, so if I want to stay there until 9 o'clock and sell extra cruises, I get to keep that money. If you do the same thing, you get to keep your money. And they said, sure, that sounds like a great idea. So I'm preparing the partnership agreement for them, and they're busy with learning the franchise operation. They're getting premises. They're putting in phones and computers and hydro and desks and things, and they're going on what they call familiarity tours or fam tours. They go on to the cruise ships and they have dinner before it leaves or something, and they're doing all this, so they're very busy, very busy. And I keep saying, have you got the partnership agreement? Yeah, we'll look at it later. Yeah, we'll look at it later. Pretty soon they're operating, and well, this is all brand new, and we're very busy, and we'll look at it later. They never signed it. My client gets an opportunity to do something extraordinary. There's a Holland America cruise ship that goes from Vancouver to Alaska and back, and that's a 7-day cruise. And it's coming back, and it dings its propeller, and it has to come into Vancouver, and it's going to take 2 days to repair the propeller. Well, that means the next 7-day cruise they cannot do, because suddenly it's a 5-day cruise, but they've sold all these 7-day cruises, so they have to give all the money back to the people. And then the ship is going to be there for 2 days while the propeller's repaired, and then it's going to sit there for 5 days until the next cruise. And this is all downtime. They have to pay the crew. They can't say, okay, you guys are all let go, and then what do they do when it's time to start operating again? So it's sitting there for 5 days, and my client goes and he says, hey, listen, guys, I tell you what, I'll charter the ship for 5 days. You provide the crew and the ship, and I will pay you, and the ship will go from Vancouver to Alaska and back, but no ports of call. And they say, oh, sure, that's great, because now at least they're getting 5 days of revenue instead of losing 7 days of revenue. And then my client had a relationship with a big association in town, the BC Automobile Association, BCAA, and they wanted to do something special for their 50th anniversary, their annual general meeting, the 50th anniversary. And so my friend goes to him and says, okay, I tell you what, how would you like to go on a cruise for 5 days to Alaska for your 50th anniversary? And they thought, this is fantastic, right? And so on the ship, there were 1,200 rooms. Now there are, 5,000, 7,000 rooms. But back then it was a small ship, 1,200 rooms. He sells 980 of them like that, okay? And he does it after hours. And he comes into the office one day and he goes, I'm in the money, I'm in the money. And he explains to his partner what they were doing, or what he's doing. And she goes, wow, how much are we making? And he goes, no. How much am I making? Because I'm doing this after hours. And she said, yeah, but I think because we didn't sign the partnership agreement, the Partnership Act says we split all the money 50-50. And he's on the phone to me and he says, Peter, and I said, Cam, why don't you look at the Partnership Act? And you've got this section in your materials, and you should know it for examination purposes. The Partnership Act, which in section 32, I think it's 32. Ooh, wow. Oh, yeah, there's section 33. A partner must account to the firm for any benefit derived by the partner without the consent of the other partners for any transaction concerning the partnership or from use of the partner by the partner of the partnership property, name, or business connection. And I read that to him, and Cam said, well, but we've got this agreement. And a verbal contract is binding, isn't it? And I said, no, there is the law in a statute. Now you can contract out from under that, but it has to be in writing. Anyway, no. Which meant that he did most of the work and he has to pay the money back into the partnership and then it gets divided equally. Okay. So he sold 980 rooms, which meant there is 10, 11, 220 rooms left. And so the two of them then sold 219 rooms. And if you do the math, and I think if I've done it correctly, there was one room left over. They didn't sell that. That was actually given to a certain lawyer who did the charter agreement. Okay, so rather than being paid fees, they just said, okay, you have a junior suite on this cruise to Alaska and back, and I declared it as income. Okay, because I gained. Too ethical, probably. No, I'm ethical, so I declared it as income. But it was just, it was easier for them to just do that than to actually pay me cash. So anyway, you'd think he'd learned his lesson, all right? So they never did sign the partnership agreement. But a few years later, they're making money hand over fist, okay? And that took the sting out of it, all right? I mean, if you're making a lot of money, I didn't make a big lump on that project, and sort of got, taken to the cleaners by my partner, but what the hey. But anyway, the accountant then says, okay, you're making way too much money personally, you guys. We have to incorporate your company so that we can do some tax planning. So now they're going to incorporate the business, which I got to do. And they say, is there anything else we should be doing? And I said, well, yes, you had this partnership. And you should have had a partnership agreement. We saw how that worked out. So you should have a shareholders agreement to prevent problems. And so they go, oh, okay. And so I prepared a shareholders agreement and sent it down to them. And did they sign it? No. Okay. But it's, different than the Partnership Act. So like what could go wrong, eh? Well, a few years go by and my client is tired of this. Okay, it was a good idea at the beginning, but it's kind of boring, right? So he thinks, well, what I'd like to do is sell my shares and just do, sell some cruise trips as an independent agent working for the company, but get out of the operation of the company. And he finds a buyer for his shares. Okay, and then he goes to his not partner, okay? She is no longer his partner. And this is something else I really want you to remember. You never, and by the way, did I say never refer to your business associate in a corporation as a partner of yours, okay? If you have a partnership, you are partners. If you are in a corporation, you are not partners, because if you're partners, then you have joint and several liability, okay? Whereas if you say you have a business associate, my fellow shareholder, my fellow director, I don't care what you call them, as long as you do not call them a partner, okay? Anyway, he said, sure, okay, prepare this partnership agreement. And then they never signed it. And then eventually he wants to sell, and he told his partner this. Okay. He told his business associate this, and she said, well, who is this person? And they were introduced, and she says, well, yes, you can buy shares in the company, and you can come on board. That's great. We'll expand. But Cam, you don't get to sell your shares to this person. Cam goes like, what? No, no, I'm entitled to sell my shares. No, he's not. In a private corporation, the sale of shares is restricted. And if you remember back to when I was talking about this earlier, I said that in a private corporation, you have to have less than 49 shareholders, which they obviously did, and you have to have the sale of the shares restricted. In the shareholders agreement I sent down to them, I said, okay, there are two directors. If the shares, if one of them wants to sell their shares, there has to be unanimous consent of the directors. If you don't like that, then let's make an amendment. But they didn't do anything with the shareholders agreement. So the articles of the company kick in, and the articles of the company kick in says that both directors must agree. So he wants to sell, she doesn't. Stalemate. Okay, so this other person invested in shares, became a business associate. Cam was stuck in the corporation, just left and did some independent work, but never got to sell his shares. Okay, so if you have a partnership agreement, you have a partnership. Or if you have a partnership, you have a partnership agreement. If you have a shareholders agreement, you have a shareholder. Let's step back and say that again. If you have a partnership, you have a partnership agreement. If you have a corporation, you have a shareholders agreement. And you think about these things. Now, you might make a mistake. You might say, yeah, we're such good friends. Like, what could ever go wrong? So, sure, both directors must agree. And then you find out when the money's concerned, friendship goes out the window. But at least when you look at that, the lawyer would say, okay, are you in agreement with that, and do you realize there could be stalemates, or do you want to have some mechanism for resolving such a stalemate, like having the matter referred to arbitration, okay, or something like that. Okay, now, don't refer to your business associate in a corporation as a partner. But a lot of people make that mistake, okay? It's natural, almost natural. I live in the Sunshine Coast. I take a ferry back and forth when I'm teaching, but I am also practicing law at this point, and this fellow comes up to me that I know, and he's a business person, and he's on the ferry, and he thinks, hey, here's my chance of getting some free legal advice. So he comes up to me and he says that he's having a problem with his partners in his business, and, could I give him assistance or whatever? And he starts talking, and then he mentioned, the corporation, there's, like 4 of them involved. And I said, well, wait a minute, Rick, give me your business card, and I'll give you a call, and I'll come into the office because, and then we'll talk about a retainer. Okay, so he was a little upset about that, obviously. And then he hands me his business card, and there's the name of the corporation, and there's his name, and under his name there's partner. And I said, okay, do you have a corporation or do you have a partnership? And he said, no, I'm a partner in the corporation. And I said, okay, you had better come in, give me a retainer, and talk about this, because the problem with that is if someone thinks you're a partner and thinks these other individuals are your partners, call yourself a corporation, but you're going to get sued as partners, and the judge is going to say, well, they are entitled to assume that you must be in a partnership because you call yourself partners. So instead of having limited liability, you have joint and several liability because you referred to yourself incorrectly. All right, now I think that that concludes corporations, with the exception of I want to talk about the corporate minute book, and so I'm going to put this on hold and just grab an example. I'll be right back. Okay, to conclude the chapter on corporations, I wanted to talk about the corporate minute book for corporations. We think of Exxon as this, huge multinational corporation with this huge building in New York with Exxon on the top of it. And in actual fact, they have a corporate solicitor. I guess they call it a corporate attorney down there. Anyway, Exxon is a book on a shelf in that lawyer's office. Okay, so this is a corporation of one of my former clients. And on the spine is just the name of the company. But in this book, and I'm going to try to figure out here, is the birth certificate for the company. Okay, it's a beautiful document sent out by the Registrar of Companies, and it has the date that the company is incorporated, and by gosh, that's the birth date. There's a notice of change of address on this one. There's and then there's the incorporation application that gets filed so that you can incorporate the company. It lists the directors, and then it lists the share structure. And in this corporation, I gave them a million Class A common, million Class B common, a million Class C common, all voting. Okay, and then we had some preferred shares, and the idea is that you give them a wide share structure, and then they can do some very interesting planning for the corporation. The key tab is the Central Securities Register, and in there you have a list of all the shares that have been issued and canceled, and who owns the shares, which is public information that has to be available. As well, there is later on a blue tab called the Minutes of the Directors, or Shareholders rather, and then there's their annual general meeting, and they appoint one person as a director. Okay, and then another tab here is the red tab where we have, directors' minutes. And this is a consent resolution of the directors, and they appoint the officers. Okay, and then the last tab, which is of any concern, is one, and they put them in different places in these, so I'm not sure where it is here. Oh yeah, share certificates. Every company, whether it's a private corporation or a corporation listed on the stock exchange, has to have shares issued. Now, this is one that I did initially when I incorporated the company for the business, and then I've canceled it, and I subsequently issued the shares to the 3 people involved in this company. So the corporate minute book is all the official records of the company, and it has to be kept up to date in order to have the company in good standing.